Hello, and welcome to Semantic Reactions, the official podcast of the Institute of General Semantics. My name is Ben Hauk, and I'm pleased to be able to introduce the 25th installment of our ongoing series. For our September episode, IGS trustees Lance Strate and Susan Drucker welcome author, New York Law School professor, and former president of the American Civil Liberties Union, Nadine Strossen. As you may know, Nadine Strossen's relationship with the Institute of General Semantics dates back to 2019, when she delivered a memorable Alfred Korzybski Memorial Lecture. For this podcast, the conversation centers on legal issues such as free speech in the context of contemporary American politics and culture. Let's hear what they have to say.
Welcome to another episode of Semantic Reactions. My name is Lance Strate. I'm here with my fellow IGS trustee, Susan Drucker, and our special guest for this episode, Nadine Strossen. Nadine is a former president of the American Civil Liberties Union, and she teaches law as a professor at New York Law School. And most important of all, she's a former Alfred Korzybski Memorial Lecturer back in 2019. And it was very wonderful to have her with us just last week for our 2024 Alfred Korzybski Memorial Lecture with Marianne Wolf. And Nadine, what was it again? Why was it that you decided to come to see Marianne?
Marianne used to be my sister-in-law, but subsequent to her divorce with my now with my brother-in-law, no, he's still my brother-in-law, he's my husband's brother, or no, he's, right, exactly. So he's still my brother-in-law, but she now describes herself as my sister outlaw, which is a nice pun. We remain extremely good friends. And as you saw and heard, she's a remarkable person. And in some ways, it seemed odd that both of us would share this, what we both consider a great honor of delivering this very special lecture, because our fields of expertise are so different. I'm a First Amendment constitutional law scholar, and she is, of course, a neuroscientist who focuses on literacy issues and reading and learning, a whole different area seemingly. And yet, I think this speaks volumes for the importance of Mr. Korzybski and your organization, that you are so wonderfully interdisciplinary and embrace so many different fields of knowledge that are relevant to the overarching theme of communication, if I had to choose one word, right?
Yeah. Well, and thank you very much. You know, we appreciate the flattery. And in-law, outlaw, both of them seem to describe you. As I understand it, you're originally from Jersey City, but grew up in Minnesota and graduated from Harvard Law School.
That's all correct. And then
Yeah.
after graduating from law school, I had spent 7 years in Cambridge, and I was very homesick for not the Midwest in general, although I love it, but I have a particularly fond spot in my heart for the Twin Cities. It's a very special place, culturally, scenically, politically. So I happily went back there to start my legal career, but I had an itch to develop my professional skills in a way that I thought might be more intense by practicing for a couple of years in a major Wall Street firm in New York. So I went to New York with the intention of staying there for a couple of years, but that was in 1978.
And here you are today.
Mhm.
Were you always interested in law, or what, what brought you to the bar, so to speak?
Well, first of all, I have to say I really prefer to talk about issues than to talk about myself, but my overall preference is to talk about whatever the host wants. So if you really want to hear my personal story, I'd be delighted to share it. I had always had an interest in free speech and a commitment to free speech long before I had any idea of what law is, Lance. And, from my earliest age, I remember just an instinctive sense that I ought to be able to express myself, and people who were trying to stop me from doing that, including parents and teachers, were overstepping their proper bounds of authority. I once said that just because I'm regularly asked that question. And I remember somebody reacted by saying, "Oh, you were just a spoiled child." And uh, but I defended other people's rights. It wasn't just for my own sake. I got quite upset even when grade school teachers would punish other students for speaking out of turn, or saying something that they considered to be disruptive. I became interested in law for the first time when I was a high school debater, and we had a debate topic one year that was a legally related topic. I used to get on the public transit and take a bus over to the University of Minnesota Law School Library and do legal research for that debate topic. And I found it absolutely fascinating. But here I'll tell a story on myself, which I hope is an object lesson for younger people listening, that I had never met a lawyer at all. My parents didn't live in that kind of neighborhood, operate in that kind of social circle. And I had never even heard of a woman lawyer at that point, and it just never occurred to me that I could be a lawyer. So I had a failure of imagination. I remember saying to my debate partners, all of whom were guys, you ought to become lawyers. But it didn't seem to me that that was a path that was open for me. Since then, I've read about the most extraordinary women early in history who had no role models at all, and that didn't stop them. So I recognize that I'm not such an adventurous, pioneering spirit, and I really salute those who are. Although I think having had my eyes opened later on to that possibility when I went to college and did meet my first women lawyers, and it was like a light bulb going off in my head. Oh, I can do that too. So number one, mentors and role models are very, very important, but all of us should have the self-confidence that we don't need. We can potentially be the path breakers ourselves. We don't need to have forerunners.
Well, and you say, and I think many of us don't like to talk about ourselves. I mean, we certainly have had more than enough of other people who do want to talk about nothing but
I always
themselves.
love hearing about other people. I'd
Yeah.
love to hear what all of you have to tell me about your backstories, but I'm not sure what the audience's preferences are.
Yeah, I think we'll keep the focus on you, Nadine, and
Ah,
note that just in general semantics, we are concerned with the organism as a whole and its environment, to use Korzybski's phrase, and that includes the whole person. So it's good to hear that, and of course, you were the first female president of the ACLU, and that was 1991, I think, to 2008, and you've written several books, and I remember seeing yours. I mean, we were buying your book at the AKML in 2019, Hate, Why We Should Resist It with Free Speech, Not Censorship. So I have to ask you, that was 2019, right? And this was just before the pandemic. And we know that things changed drastically once the pandemic hit. So at that point, this became a real concern. The need to, in effect, censor all the bad information, all the misleading information in the interests of public health. I, what was your view at that point? Are you a free speech absolutist, to go to that point? Or is public health a line that should not be crossed as far as free speech and censorship?
an excellent series of questions. So let me disaggregate them, starting with I would not describe myself as a free speech absolutist, and I would not describe anybody as a free speech absolutist. Rather, that is an oversimplified caricature of the strong free speech protection that is supported unanimously by the United States Supreme Court and by many of us who work in organizations such as the ACLU, FIRE, the Foundation for Individual Rights and Education, and other organizations. But the charge that we absolutely defend free speech and we will not acknowledge that there should be any limits or any exceptions whatsoever, and even that we deny that speech can do harm, those are caricatured, distorted versions of what the law actually is and what we actually advocate by people who then, use it as a straw person to oppose free speech. The more you know about free speech principles and the Supreme Court's doctrine, which, to repeat a really important point that I alluded to earlier, the Supreme Court has been essentially unanimous on the basic speech protective tenets that have been in place since the second half of the 20th century. Despite all of the ideological diversity and division among the justices, they are pretty much unanimous on these key points. Now, as I tell my students, I welcome criticism. I require, critical inquiry and debate and discussion and dissension on every point. So the fact that all the Supreme Court justices have agreed does not mean that they are right. Maybe all of them are wrong. But one point that it does underscore is that this is not an ideological matter. This is not a matter where conservatives vote one way and liberals vote another way. So the more you know about these unanimously supported free speech, modern free speech, contemporary free speech principles, the more they make just plain common sense. They add up to, they're very, very complicated, but they can really be summarized accurately by saying that they do allow government to restrict the speech that is the most dangerous. And to quote a couple of phrases that the Supreme Court has used from time to time, because the speech directly presents a clear and present danger of actual or imminent harm. Sometimes the term emergency is used, that the speech presents an emergency. It either directly causes harm, such as a defamatory statement or a fraudulent statement that immediately causes, demonstrable, tangible financial harm to the person at whom the speech is targeted, or it imminently threatens harm that is likely to happen imminently. And a really good example is the famous intentional incitement of imminent violence that is likely to happen imminently. So speech that is the most dangerous, the most harmful, is subject to restriction. On the other hand, the restrictions that are the most dangerous are prohibited. And the most dangerous forms of restriction are those that are not based on a clear and present danger, but rather are based on a more attenuated, speculative, feared connection between speech and some potential harm that might happen sometime in the future, or solely because of dislike, disagreement with the message or the viewpoint or the content of the speech, that an offensive message or a discriminatory message is never alone enough to justify restrictions. Why? Not because there is no potential harm. There is potential harm by definition and in all kinds of, every kind of speech, right?
Mhm.
Even what I'm saying now could potentially lead to some harms that I can imagine. But
Wait, I want to just interject that the IGS takes no responsibility for any potential harm coming from Nadine's speech.
yeah, you
Please.
should have given a trigger warning too,
No.
because some people on some campuses, there have been posters saying free speech is hate speech, right? And because of this, what I'm saying may convince some government authority, including a university official, not to stop some right winger or somebody else from speaking. And the students will say, well, there will be students, I guarantee you, who say that speech is harming me or it's
Mhm.
harming other people. So I'm precipitating that kind of harm. Oliver Wendell Holmes said very famously, every idea is an incitement. And he did not mean by that, we should therefore censor every idea. He meant exactly the opposite, that if that alone is enough to suppress speech, there's not going to be any free speech left. So I do not support free speech, absolutely. I support the sensible, appropriately limited restrictions that the Supreme Court has upheld, consistent with the emergency principle and consistent with this other principle, which is usually referred to as viewpoint neutrality or content neutrality. Government may never suppress or restrict speech solely because of disagreement with or generalized fear about its message or its content. And yes, I rigorously apply that same framework, and more importantly, the United States Supreme Court does, to all expression that is controversial for any reason, no matter what epithet we use against it. Hate speech, disinformation, misinformation, extremist speech, terrorist speech. I'm putting all of those terms in scare quotes to underscore that they are completely subjective concepts, that therefore, if any authority, government official or university official, is given the power to restrict speech because of the conclusion that it is disinformation or misinformation or hate speech, that is simply licensing them to enforce their own subjective value judgments about what speech satisfies those inherently nebulous and manipulatable terms. Disinformation about COVID or the election, to take two subjects which often provoke calls for speech restrictions. No exception. Shortly after the pandemic, Puerto Rico enacted two disinformation laws targeting disinformation about the pandemic. The ACLU, I'm so proud, in Puerto Rico immediately brought a lawsuit challenging those restrictions on behalf of two very respected investigative journalists who said, look, especially in a fast breaking news story about a health emergency, even the most scrupulous, responsible journalist is not going to be able to be 100% accurate. And we believe it's most important to get out all of the information, all of the claims, all of the different perspectives, and let people decide for themselves. And fortunately, a federal judge agreed with us and struck down that law, and underscoring that point said it is worse for public health to impose these loose restrictions on misinformation or disinformation, because it's going to deter reasonable journalists. If they're not 1,000% sure of what they're putting out there, they're going to self-censor and they're going to stop themselves from putting out information or opinions or analysis or theories that consistent with the scientific method, right? You put out every theory. You don't say it's true. You say, X scientist has floated this theory, and then you let Y scientist or public health policy wonk debate it. And that is far better for public health than allowing the government to keep strict controls over what is said and what is not said. We have seen so many examples of even the very same public health officials changing their statements. I'm not saying changing their mind, but as new information comes in, right? The overall analysis changes. And, just recently I was listening to National Public Radio doing a story about how for such a long time, anybody who dared to talk about the so-called lab leak theory as the cause of COVID was being censored and suppressed and called, insulted as a conspiracy theorist, and how scientists have now come around and public health authorities have come around to saying there is a lot of credibility behind that, and that NPR was voicing as a theory that part of the reason why the government didn't want that potential explanation to be circulated was because of the United States involvement in these laboratories. And, I was happy that this was coming out, better late than never, but I was very irritated that NPR did not apologize, because they were among the many so-called mainstream outlets that just completely subscribe to the government line, to the best of my recollection. I haven't
But
gone back and researched it.
but Nadine, I mean, what about the examples where we had people denying the pandemic? Was it all serious? People didn't have to take any precautions, or people putting out kind of bogus cures that not only didn't work but could potentially be harmful. I
Right,
mean,
I'm
is
sorry,
there,
I'm going on a filibuster, but I told
yeah,
you, your question, I haven't even gotten to all the parts of your initial
well, okay.
question. But no, I'm not complaining. I'm just apologizing and explaining, because I saw that Susan had her hand up too. So I'll try to answer this briefly and then hear Susan's question or comment. That again, the law is very sensible, consistent with the emergency principle. Certain kinds of false expression may be restricted. But the limits are appropriately tight. So if anybody is free to voice a, opinion that may be, or a theory that is not backed by evidence. You don't have to have, a PhD or knowledge to make statements in the public square. And I think it would be very scary to have government vet everything we say for what is considered to be scientifically accurate. And this, as the Supreme Court said, there's no such thing as a false opinion. But if you are talking about fraud, where somebody you intentionally aim your remark at a particular individual, and you intend that individual to rely on what you are saying, and you make a false statement of fact. Again, there's no such thing as a false opinion or a false idea, but you make a false statement of objectively verifiable or falsifiable fact, intending somebody to rely on it to their detriment, and they do rely on it to their detriment. That is punishable fraud. But when you're talking about statements that are made in public debate, in widespread, conferences or online webinars, contexts where, it's not one-to-one attempt to do harm to somebody by their reliance on you. The answer in our free society for all of the information and disinformation that's swirling around is something that all of you are experts on, and you've been doing, I'm sure, throughout your whole careers, which is educating everybody to be responsible consumers of information, which has always included disinformation. Among other things, even if we had the most repressive government in the world, and it had license to try to stifle misinformation and disinformation, it can't be done. We know that from other examples that exist today and have existed in history. So the only sure immunization against the dangers of disinformation are to equip each of the members of the audience, every member of the public, with a healthy dose of skepticism about everything we hear, see, and read, including from the most respected authorities. Just because it's coming from, Biden or Trump, this is not a partisan comment, so I'm throwing both of them in there, administration officials, or even if it's coming from the American Medical Association, we should still treat it with healthy skepticism. And one great thing about the internet is that it does allow us to do our own research and fact checking much more quickly than has been feasible in the past. Susan.
Huh, This is all fascinating. And I've been very interested in language crimes, incitement, seditious conspiracy, perjury, bribery, where the wrong is committed by the word. And I'm interested in how that relates to kind of the current information environment filled with misinformation, disinformation, and hate speech. So I'm wondering, I'm looking at the current political environment, for example, and I'm wondering if, as you said, misinformation has always been out there. Well, so is negative political advertising. And I'm just wondering if in the current political environment, the current political campaigns, if you think that there's a difference between what we've seen before in terms of negative advertising and what we're hearing now from leaders, where what they say in the context of a political campaign could amount to hate speech.
So first of all, Lance, I would love to give you a chance to respond to my answers. I just felt seriously, but I felt out of courtesy to Susan, I should first proceed with her question, okay? Because
Absolutely.
I didn't mean to
Absolutely.
come full stop. I really want this to be a dialogue, but in some ways, Susan's question is really a follow-up, right?
Yeah.
Because you're just pressing on other specific examples of false speech or otherwise controversial speech that could potentially be harmful, no doubt about it, but does not amount to an emergency and would not be subject to censorship under American law. Nor if we think about it together aloud, I doubt that any of us would want it to be subject to the kind of censorship that we see of political campaigning in Brazil, for example.
Mhm.
Let me give you examples of election-related lies, not to put too fine a point on it, that have, in my view, and more importantly, in the view of some judges who have ruled on it, been held to satisfy the fraud standard category of emergency, clear and present danger speech. And that is if somebody gives misinformation, and let me get rid of, not use that. I'll censor that term, self-censor that term. If somebody lies about voting procedures, such as what day you vote, what time you leave the ballot, the polls are open, what the methods are for voting by mail, and not in just a general proclamation, but rather individually targeted or targeted at identifiable groups, and intends them to rely on that lie in order to defeat their opportunity, deny them an opportunity to cast a vote. Oh, you don't have to vote until Wednesday. and the
Mhm.
election is on Tuesday, or you can vote simply by sending an email to such and such an address. And I've heard email address, and you don't have to bother with an official ballot. And I've heard allegations of that kind of misleading statement or false statement that can be punished both under the so-called common law of fraud, but many states have passed and have enacted narrowly drafted laws targeting that specific kind of lie about the election process, which will literally deprive somebody of their right to vote. That is distinguishable from the kinds of, I don't know, disinformation about policy issues, right? About, or here's another example, campaign promises. I've had many people say, well, if a candidate promises that they're going to raise the minimum wage or, stop imposing sales taxes or on tips or whatever, or they change their position on abortion, to use some very non-hypothetical examples, shouldn't that be punishable? And the answer is no. And that the answer, as always, in saying that speech should not be punished is not because the speech can't do harm. No, it can do a lot of harm, but because of the assessment that if we created the criteria that would enable the government, empower the government to punish speech on that rationale, so much speech would be endangered that it would do more harm than good. I mean, so I don't know what example we want to tease out, but let's say any candidate who makes a statement about a public policy issue that a fact checker would say is not true. And by the way, occasionally I'll look at ProPublica or others who do fact checking, and every single speech of every single candidate, they have many examples of false statements. There are different degrees of falseness, but every single candidate says things that are blatantly untrue. So if we in fact want the government to punish them somehow for doing that, it's going to have an enormous chilling effect, which is not only going to stop them from flat out lies, but in the overall context, I think we have to read these as rhetorical, right? Exaggerated, hyperbolic. Here I am talking to experts in communication, that they probably don't necessarily intend people to take it literally, but just to give an overall sense of what their goals and what their aspirations are. In Brazil, where they have special election courts that literally, it's like fact checking on steroids, where they've been punishing candidates and, putting prior restraints on them and their supporters for saying things that to me are just matters of opinion. I mean, one example I remember is a so-called pro-life, anti-abortion candidate saying abortion is murder. That was considered punishable because didn't think that was accurate. So, the one metaphor that I like to use, Susan and Lance, is free speech is very dangerous. It is less dangerous than empowering the government beyond the appropriately constricted power that it now has to suppress speech under the emergency principle. And the analogy to me is Winston Churchill's famous aphorism about democracy: is the worst form of government except for all the others.
Right.
To follow up, when you're talking about the court decisions and all, and it seems to me that that we're also at a particularly political volatile time in terms of legal precedent. Time binding is such a fundamental concept in terms of general semantics. And I always talk about time binding in relation to legal precedent and stare decisis. And it strikes me that in this political climate, we're on the, I'd like to say precipice, but I think we're over the precipice in terms of what's happening to certainly the high court's reliance on precedent. And I was just wondering what your opinion on where we are in terms of relying on precedent is in the current environment.
I'm delighted to answer that excellent question, but I confess I don't know the concept time binding. Could you possibly give me a brief explanation?
I'm sure Lance can do this better than I can, but if you think about the transfer of knowledge from generation to generation, and how knowledge is increased and enhanced by the sharing of information over time from generation to generation.
That sounds very much like the common law approach to law, that we each precedent not only adheres to what has gone before, but builds upon it. So it's intentionally an evolutionary process. And it is not absolute, nor should it be, or we'd still be stuck with decisions like the Dred Scott decision or Plessy versus Ferguson, which, and we can think of others that is a good thing. The court was not absolutely bound, but there are some issues on which the court is much more volatile than others. And let me just bring home a general point I made earlier and make expressly clear, Susan, what I didn't make expressly clear. My generalization about the Supreme Court, notwithstanding all of its ideological divisions on other issues, is still 100% firmly committed to these two core concepts of, number one, government may never suppress speech based on viewpoint discrimination. The dislike, disapproval, even loathing of the message of the speech. Every single one of them is completely on board with that principle. And number two, in contrast, when in a particular circumstance, any message directly causes or imminently threatens certain specific serious harm, i.e. poses an emergency, a clear and present danger, then it may be restricted. So they're unanimous on the principles to this day. Of course, in enforcing those principles, in especially the second one, in a particular factual context, there will be a disagreement because it's not a scientific test. And what one justice thinks does satisfy the emergency test, another one will not. So, for example, there have been different judicial opinions and different opinions among legal scholars as to whether Donald Trump's speech on January 1st, put in the context of, January 6th, put in the context of.
And I was going to ask about that one too.
What led up to it and what ensued. Does that satisfy the standard of intentional incitement of imminent violence, which is likely to happen imminently? And there is a complex welter of facts there. And I've seen quite persuasive arguments both for and against that conclusion, because from the overall factual situation, including what he said, the words themselves, because he was, I think, very shrewd or very shrewdly advised to temper some of the more inflammatory language with, but we go in peace, some language that leavened the arguably inciting message. And then there are contextual factors that also weigh on both sides. So it certainly can be disagreement as to how the precedential principles should be enforced in a particular factual context, but I see no disagreement about those fundamental principles to this day. And again, that doesn't mean they're correct. But I would certainly say I continue to believe that they are correct, especially as compared to the alternatives.
And I guess for me, one question that comes out of that, and I think a colleague of mine at Fordham University, Paul Levinson, was very strong. I mean, kind of maybe not an absolutist, but close to one on the First Amendment. And after January 6th, after the pandemic, he's moderated his views on that. And so I'm just wondering if the events, since you're AKML, and you're, very impassioned defense
Mhm.
of the First Amendment, have your views changed at all based on the events that we've all experienced over the past 5 years?
If by views you mean my principles, that's kind of interesting because this is not an endorsement, but I'm associating myself now with something that Kamala Harris said about her changing positions on issues. And, I have no idea whether this is factually accurate or not, but I basically recall her saying something like, my values have not changed.
Right,
I
right.
think that's true for the various scientists I mentioned. That's why I said they didn't change their minds. It's just that so they still were using the same analytical tools. They still had the same public health goals, but it's just that new evidence came in. And you apply that evidence to the same principles and approaches, and it leads to a different result. So with the greatest respect for you, Lance, I would wonder whether your colleague really changed his principles or whether he's saying the evidence that has come in does satisfy the emergency test, that these restrictions are necessary in order to promote public health or to protect, further damage to public health.
Mhm.
And by the way, let me say that another way that the Supreme Court, you're all interested in language, another way that the Supreme Court phrases the emergency test is often called judicial strict scrutiny, that the judges will carefully scrutinize the challenged restriction, demanding that the government satisfy a burden of proving that the particular restriction is necessary and narrowly tailored to promote a countervailing goal of compelling importance. And necessary literally means necessary, that no less speech restrictive alternative would be as effective in advancing the goal. So clearly the goal of public health, of protecting public health, of countering the pandemic, of course, that's a goal of compelling importance. The debate is only over whether particular restrictions, including restrictions on expression, are necessary and narrowly tailored and the least speech restrictive alternative in order to promote that goal. I would seriously doubt that your colleague says that he wants to deviate from that standard and reduce it and give the government more discretion. I may be wrong, but I would not be at all surprised if he said, I think there has been evidence that, that various statements that scientists or others have made should be restricted consistent with that test, because it is necessary to stop them from saying that in order to protect public health. So that's more a debate about facts than it is
Yeah.
about the standards or principles.
Well, I'll leave it to him
Your point
to
about
determine whether what you're saying is actually the case or not.
Yeah, because if you change the standards, then you're changing it, the ramifications are enormous. Let's say we decided that we would go back to the mid 20th century speech protective standards, which by the way came out of the civil rights movement. No coincidence, because when we had less speech protective standards, who was being censored? Martin Luther King wrote his famous letter from a Birmingham jail. He was imprisoned because then because he simply wanted to engage in what we now consider the most important kind of speech in a democratic republic, dissenting from and criticizing, seeking to reform government policies that you believe are unjust and actually unconstitutional. But before the Supreme Court adopted the emergency standard by a majority, it had been endorsed by path-breaking, pioneering, dissenting justices, including Holmes and Brandeis, most importantly, much earlier. But it was adopted by a majority in the 1960s. Before that, the standard that the court used was a so-called bad tendency. If the speech has a tendency to do bad, to do harm, a tendency. It doesn't have to be imminent. It doesn't have to be direct, but it might lead to harm. That's enough to justify censoring it. And I think that would be the standard that you would have to use if you were to broaden the net of the disinformation related to the pandemic or to any other topic that would be subject to government suppression. And then, as we see from history and as we see around the world, predictably, that kind of loose discretion that's given to government officials is disproportionately going to silence critics of or dissenters from government policy, certainly racial minorities, religious minorities, basically anybody who is not part of the powerful majority.
So I just wanted to go back to your point about not changing principles,
Mhm.
but reacting to changing context. There's been so much discussion about the High Court's attitude about precedent in terms of the Dobbs decision, the presidential immunity decision, the decision on administrative agency rights, and the Chevron overturning the Chevron decision about administrative agencies, really shifting power to the courts to decide on certain interpretation of rules and regs. It seems to me that what you're suggesting is exactly kind of the touchstone for what the justices are using to rationalize or to their seeming break with precedent in this era, that there's been a tremendous amount of concern and criticism of turning these prior precedents. But if you make the argument that it's principle rather than overturning precedent, that they're sticking to the same principles, then it doesn't seem as if we're in quite the precarious situation that some fear we're in with regard to
It's a very,
precedent.
very interesting question, Susan. But first and foremost, I want to point out that there are many Supreme Court decisions that overturn precedent that liberals and civil libertarians and human rights advocates and equal rights advocates champion. In terms of precedent, no matter who you are, no matter what your beliefs are, including about constitutional law issues, there will be some precedents that you will urge the court to overturn and to depart from. So one dramatic example is a fairly recent Supreme Court decision overturning a fairly recent precedent. The more recent one was Lawrence versus Texas, overturning Bowers versus Hardwick. And to the best of my recollection, Lawrence was in the early 2000s, I think something like 2005, overturning Bowers versus Hardwick in around 1986. And in Bowers, the Supreme Court had held that the Constitution does not prohibit states from criminalizing consensual sexual intimacy between same-sex partners. And it upheld so-called sodomy laws that made it a crime for consenting adults in the privacy of their own homes to enjoy sexual intimacy with each other. The ACLU, which had argued that case in the Supreme Court, and other advocates of LGBTQ equality kept urging the Supreme Court to overturn Bowers versus Hardwick, and it finally did so in Lawrence versus Texas. And that was seen as a great victory, and that it was justified for the Supreme Court to depart from precedent. But then so people tend to be result oriented in terms of how adherent they are to the principles of adhering to precedent. And in fairness, in law, we use the Latin term stare decisis, stand by the decision, for the doctrine of generally, but not always, respecting precedent. There is not an ironclad rule, rather there's a series of factors that are to be taken into consideration, and they may cut in different directions, and different justices will assign them different weights. But one is, so one factor is, was the case wrongly decided at the outset? Was it a misapplication of the existing legal precedent? You have many cases are decided 5-4, so that's a plausible argument. Number two, has our law evolved since then, such that even if it was correct at the time it was decided, those principles themselves have evolved in a way that make it no longer a justifiable holding. Number three, and this would weigh against overturning precedent, have people relied on it? Has society relied on it? Have people made major life decisions that would be overturned and adversely affected if we overturned this legal precedent? So I think that I can't say that I have scientifically examined whether the current court has played more fast and loose with precedents than other courts. I certainly know that conservatives and people who were advocating law and order, that was the buzzword at the time in the 60s and 70s, were very upset at the court under the leadership of Chief Justice Earl Warren, that was overturning many precedents, not only that were inconsistent with the equal rights of Black people, but that also suppressed free speech rights for civil rights demonstrators and anti-war Vietnam War protesters, that also opened up brand new procedural protections for people who were accused of crime. All of that was wildly inconsistent with, centuries of precedent that had gone before. And liberals were the ones that were cheering that.
I'd like to ask you about a couple of things related to new media, social media that are going on. One is Elon Musk's takeover of X Twitter, where he threw out all the stops, or at least argued that he was in favor of complete free speech. And the other is the effort that's going on to have TikTok sold from their Chinese owners. So I was wondering what your thoughts are about those two cases, not legal cases so much as just those two things going on
Well, TikTok, as you know, does present a legal case. There recently was an argument in the legal challenge that was brought by TikTok, and I believe also by users of TikTok, that their free speech rights are being violated by the new law that Congress passed. And so let me start with that. First of all, by virtue of the fact that there are challenges from users as well as from the company itself, underscores a really important point, which is that the First Amendment protects not only the right to convey information and ideas as a speaker or as a platform, but also the right of audience members to receive information and ideas. And in this case, I guess when you're talking about platform users, they are acting as both speakers and as audience members, and they certainly have important free speech rights that are implicated. I hate to sound like a broken record, but it's another illustration of the applicability of the emergency principle. The debate in the legal case and in the recent argument was specifically over whether this particular restriction is necessary, narrowly tailored, and the least restrictive alternative in order to protect the national security interests that the government says are at stake. And certainly national security is a very important concern. So the issue is not whether that would be a justification for restricting TikTok, but whether that is a necessary step in order to do so. And there's strong arguments both ways. On the question of X and Twitter, Elon Musk made grand pronouncements about adhering to free speech, but did not adhere to them very long. He very quickly came to understand that if you want to preserve your customer base and by providing a pleasant experience for them, you simply have to suppress certain speech. Just think of spam. I mean, would any of us remain on that platform if we were not protected against constant spamming? So neither Elon Musk nor any other platform operator I suppose they could make a choice to literally engage in no restrictions at all, but that would be such chaos that nobody, even the hypothetical free speech absolutists, would want to be subject to that kind of platform. Those concerns are exactly what prompted Congress to pass the famous so-called Section 230, which is a provision in the Communications Decency Act passed in 1996, almost unanimously, that assured platforms that they could remove any objectionable material, and it literally used that open-ended term objectionable, without opening themselves up to the kind of liability that would apply to let's say a newspaper, the price being, Congress was negating the implication that by doing some screening, you therefore are held accountable for everything that you have not screened out. They understood that given the vast numbers of communications here, that you needed to both immunize the platforms from responsibility for illegal content that somebody else put up, recognizing that they can't possibly screen everything, but on the other hand, allow them to do some screening of the most egregious material. And to me, the best example of that is spam, because I don't know anybody who's in favor of that.
I think in regard to what we've been talking about, and back to time binding, I mean, it's always been twofold. That is, as a general human principle that we are the only form of life that is able to collect information and pass it on from one generation to a next and make progress, but that it also involves evaluation and determining what of that information that's been handed down is inaccurate. And that also relates to distinguishing between fact and opinion, the point that you brought out, and also between facts and inferences, where we're making assumptions that may or may not be true, but we can't know that as compared to facts that we absolutely know to be true or false for that matter.
Most of the examples that I hear of so-called misinformation or disinformation that people want to be censored, and I'm so glad you brought that up, because it is in the last few years, maybe because of the pandemic, maybe because of the last presidential election, or both, the most unpopular kind of expression. It used to be hate speech, but now it's misinformation or disinformation.
It's interesting what's going on, that the EU has really stepped up its demands on EU members to take active participation in changing their laws.
But they've censored everything, including hate speech. And if you see
I was following the
examples,
case in over the summer with the arrest of the CEO of Telegram, that that
yes,
were making an example of him for not
Right.
moderating and.
Right. The examples of governments in Europe that are cracking down on, critics of government health policy, it's really scary. I mean, so to me, that's an object lesson of a direction that we don't want to go.
Well,
So,
WikiLeaks also, and Snowden.
yeah, yeah.
Actually, just in terms of wrapping it up, one of the things I'd like you to know is that I assign your book on hate speech.
Thank you.
There is such a direct link to general semantics in so many ways. Certainly, you
Hmm.
explained that in your AKML talk from years ago. But the what I always try to deal with my students is how vague languages and abstraction, how many problems can be caused by vagueness. And
Mm.
it seems as if that's so much at the heart of what we're dealing with, and we deal with hate speech and misinformation and disinformation. And it goes right to the heart of so much of what I think of what we learned from general semantics about
Interesting.
language.
Yeah. Interesting. Well, there certainly is a new passion now for information literacy instruction, and a number of states have mandated that it be incorporated into their curricula, starting K through 12, which I think is really important. Studies indicate that even college students at prestigious universities are amazingly unsophisticated in analyzing what's true and what's false and what's misleading, that they tend to be oriented toward how well something is presented. So if it's presented in a visually appealing way, in a professional looking way, they tend to believe the content and the message. Quite alarming. On the positive, as an activist, I'm an optimist. So to me, the positive is that there's so much information illiteracy, that there's a lot of low-hanging fruit that I think not that much instruction could make a big difference.
Well, and that's what the Institute is all about, is, teaching people the difference between a fact and an inference, and how to evaluate information, how to evaluate knowledge. And I think that's, very much to the point. And this has really been great, Nadine. I think we've had a wonderful conversation, and just really wonderful to reconnect you with the Institute. And
I
to
really
continue.
appreciate the opportunity to be part of the conversation. It was a real pleasure. for me.
Thank you so much. I really have a wonderful time every time I get together with members of your organization or events of your organization. So, and that includes this podcast. I'm really honored to have been a guest on it.
Well, the honor's all ours. Thank you very much.
Thank you so much. Have a great weekend.
You've been listening to our September 2024 episode of Semantic Reactions, featuring Nadine Strossen in a dialogue with IGS trustees Susan Drucker and Lance Strate, talking about law and free speech. If you like what you've heard, or even if you haven't, please consider becoming a member of the Institute of General Semantics, if you're not one already. In addition to supporting our efforts, IGS members receive an annual subscription to our journal, etc., a review of general semantics, access to our online and in-person events, lectures, and seminars, and discounts on the books and audiovisual materials that we sell. Regular membership is only $50 and half off for students. Your membership and any additional donations you care to make will help to support our offerings and activities as we work to bring a measure of sanity to the world. The Institute of General Semantics is a 501c3 nonprofit organization dedicated to research and education on a wide range of topics. They include language and symbols, meaning and perception, communication and representation, media and technology, science and epistemology, creativity, and critical thinking. We are dedicated to making the world a better place through practical strategies for improving our semantic environment, individually and collectively. For more information about the Institute and our activities, and to become a member and supporter of our work, please visit our website at generalsemantics.org. That's generalsemantics, one word, .org. And this brings to a close our 25th episode of Semantic Reactions, the official podcast of the Institute of General Semantics. This is Ben Houck, signing off, saying, we hope you'll join us next time. And until then, just remember this simple fact, that the map is not the territory.